Good morning. This is Bonnie Sternwasser. I am the staff attorney for Washington New Americans. It's currently January 4th, 2019, and we have decided to update the training for the volunteer attorneys and DOJ representatives. I want to thank you very much for volunteering to work at Citizenship Day clinics or workshops. And your role is really, really important, and we're also very thankful to have you, and we know the clients that we serve will be thankful to have you also. So just a little background. Ayla Washington, primarily Paul Soref, started the first Citizenship Day back in 2004, and in 2008 we formed a partnership with Washington New Americans, which is the citizenship function of One America. And during that time, we developed this program so that One America would provide the logistical support, and then the attorneys just show up and do their thing, providing pro bono legal services. And having worked with One America both as a volunteer for many years and recently on staff, I am extremely impressed with the incredible work that the staff does here to provide logistics and outreach and recruitment of clients and attorneys and other volunteers. So this program is funded by the state of Washington in part. They give us a grant that helps underwrite the program and also helps to support some other nonprofits in the area that also provide citizenship services, and they help out at our pro bono clinics. So this training will involve the following topics. We'll discuss the logistics for the day, how the flow of clients and attorneys will work. We will talk about the philosophy of the workshop setting and what we hope to accomplish. We'll also talk about the different roles for the attorneys and DOJ representatives. And we've recently updated all the intake sheets and have created a secondary screening guide that we'll go over. And we'll talk about the importance of you taking very careful notes. We do have to often go back and review what happened for a particular client, and as well for the grant that One America receives, there's a lot of follow-up and reporting that is done to the state, so those are really important. We will talk about when and how to do red flags and refer people out, and we'll talk about quality review and what happens after that. And then we'll go into the bulk of citizenship and naturalization law and what some of the recent hot topics are. And then we'll take a look at the form as well as the fee waivers. We'll discuss a little bit. One America recently became a qualified legal service provider under the Washington State Bar so that you can receive CLE credits now for your pro bono service. So in order to get those credits, you have to watch this webinar. It's about 1.5 hours. We may go over a little bit. On the day of the event, we ask that you come early and attend the orientation. We do a walkthrough as well as a station-by-station orientations, and your station is really important. So we usually spend a half an hour to an hour dealing with that. And then we ask that you sign in and out on the volunteer sign-up sheet when you walk into the clinic. But you're going to be reporting your own CLE credits, and the link for doing that is below. By the way, you'll be getting by email a copy of this PowerPoint, so don't worry if you haven't received it yet. So most of our workshops have this particular timing format. Approximately, they may vary depending on when and where we're doing a program. So essentially all the volunteers arrive at 8:30. As I mentioned, we'll do a walkthrough of the entire site so you can see the flow of how the clients will spend their day and where all the volunteer resources are. At 10, we'll start the legal screenings, and just for your own information, depending on whether this is a multi-day site, official citizenship day, or a specific roving clinic, some folks may have appointments and other times we may just take walk-ins. We expect you to be there at least till 5 or 5:30 approximately, and especially for those attorneys that are assigned to quality review, we do need you to stay to the very end until the last client has been completely finished up. We sometimes get questions from them at the very last minute, so we need you to be available for that. If you need to leave early, please let one of the One America folks know in advance, but we really want you to commit to the full day. That helps with us in terms of scheduling who's doing what and for how long. We always provide you with food and drink, and often our local hosts will provide food for us, so we think you'll appreciate that. And if you have a specific diet, you should bring your own food. And sometimes we have pre and post-event get-togethers, depending on when and where. So the main idea of Citizenship Day is that the clients will be seen just that one day by an attorney or DOJ rep, and they will then hopefully leave the clinic with a prepared N-400 and further instructions, and then they will file the application themselves, go to their biometrics, and interview themselves. So we are looking for the cleanest, simplest cases, and to get some understanding of whether the client can really represent themselves at an interview. If not, then we may suggest that they get counsel or refer them out. So the two main goals are, is the person safe to apply for naturalization? We don't want them ending up in removal proceedings. And can they be successful on their own? If no, we have a little red slips that I'll show you shortly, and you'll give them instructions for what they need to do. And we have lists of private attorneys and nonprofit organizations that can help them where required. Also, it's really important to realize that even if you red slip a client, it's not considered to be a failure. It's actually a huge benefit to many of our clients, because for some, they've never been to an attorney before, or they don't have enough information to make decisions on their own. And so I want you to feel like if you have to red slip someone, they're still getting a benefit out of having come to the workshop. So the two primary roles that we have for the attorneys and DOJ reps are screeners and quality review. The screeners will go through an intake process to determine if the person is eligible for filing for the N-400, and if so, they will then go to a paralegal station where the folks there will prepare the application, and then they'll come back to the quality review attorney. And these will be our more experienced immigration lawyers who will review the completed application for quality, of course, accuracy, completeness, etc. And then we'll send them along their way with a blue folder with various other informational documents and what they need to do next. We do want attorneys who have little to no experience they can volunteer to be paralegals, or they can observe screenings, or they can do other functions. But we do require that people have at least 2 years immigration law experience or have completed at least 5 naturalization applications. So this is basically the process. So the clients will be given a blue intake sheet when they arrive. And on this, it has some demographic information, how they heard about the program, et cetera, et cetera. And they'll put in like their addresses last 5 years, employment last 5 years, all their relatives, kids, former and current spouses, that type of information. When they go to the legal screening station, you will be using a yellow intake sheet that has extensive questions to help you probe further about their eligibility. And this is the form that we really need you to take careful notes, especially if you're a screener. We need you to keep in mind that the paralegal is going to be looking at your notes and the quality review person will be looking at your notes. And One America staff may be looking at your notes later if the client contacts us if there's a problem. At the forms completion station, that's where our paralegals are, and they will complete the N400s and also the fee waiver and or reduced fee forms. So the screener will not be getting into fee waivers very much, but the quality review person should know something about fee waivers and reduced fees, and there is information in the attorney notebooks that will be on each of your desks with samples and stuff like that. We'll talk about this a little bit later. Then the quality review person will review everything for accuracy as described. We do not want the same person doing screening and quality review. We need at least 2 different sets of eyes on all the cases. And then finally, folks with completed applications will go to our copy station where we make copies of everything that they need, and as well we prepare the envelope for them to mail in their applications. So really all they need to do is just pop it in the mail along with their filing fee. So we hope you'll consider coming to multiple clinics. It's a great way to gain experience, especially if naturalization is not the main part of your law practice. And just speaking personally, I think naturalization is sort of the more fun, better outcome possibilities area of immigration law right now, and can be a nice change of pace for those of you that do removal or the more hardship humanitarian work that is so stressful these days. The screening is really essential for issue spotting, and again, we don't want anybody showing up and at their interview only to find out that they are removable. So as we go through this, we'll be learning more about naturalization, how to screen for red flag issues, what the potential risks are, what other documents might be useful. We can send people off to file a FOIA, get criminal records, etc., and welcome them back to another workshop, or they may need more help from a private attorney. The legal screener will see when the client comes to your station that on the back of the blue form is our legal services agreement, which basically says that we are representing them just for that day. You will not be signing as preparer. We have authorization to have the host organization be the preparer, but we still expect you to comply with all attorney requirements for professional conduct, okay? You'll be screening for potential issues, and then you'll determine whether they can proceed today and get their application prepared and ready, or if they need to be referred out. So this is what the blue intake sheet looks like that they will fill out when they first arrive. The limited services agreement is over here. It's both in English and Spanish. Unfortunately, we don't have any other languages, but those who need it will have interpreters with them. So there's a space for both of you to sign at the bottom, and we need you to remember to do that. This is just a little snapshot of our new screening form. And again, try to go through it and fill out everything as best you can. Feel free to put lots of notes in that right-hand column for screener comments. And I'm the one that actually worked on this, so I would love your feedback if you have suggestions for better questions or something's not helpful or working well for you. Your feedback is really important. My email address, by the way, is on the last slide of this presentation. I've also created this secondary screening sheet. So just for example, like on the question of, has the person abandoned residence? You know, some of the preliminary questions will be on the yellow sheet, but then there's more detailed information and some citations here and there throughout this document where you might want to probe a little further. And it'll have some follow-up questions on a variety of issues. So this document sort of tracks the yellow intake sheet. This will be in your attorney notebook, by the way. On the back sides of the yellow screening sheet, we have these areas here where each station that the client goes to, the person there, the volunteer, must fill this out because it's really important that the next person that they see knows what you decided to do. So there's kind of a checklist here for the attorneys. And then there's a quality review section. There's also on the yellow sheet similar things for the paralegal station and the copy station. Really, really important. I can't stress this enough because often we get calls from the clients afterwards if something came up and we need to go back and see what happened in the case. And as I mentioned before, whatever the screener does is going to be reviewed by the paralegal, the quality review person, and the copy station. So any other special instructions, please handwrite those in. This is our red slip. These will also be on the tables and in your attorney notebook. So when the client has some particular issue and we're going to send them away, you're going to give them this red document and check off what they need to do. It's also in Spanish on the back side. And please make sure that your instructions are really clear as to what happens next for them. So as I mentioned before, the quality review person will review all the forms, make sure everything has been filled out, all the boxes checked, or there's data for everything. You're going to go over it with the client again. So you want to make sure everything is truthful and accurate. And we'll be talking about truthfulness and accuracy later on in this presentation, especially since there's a recent case dealing with this that I'll talk about. And so we want you to assume that you're the last person to review this case before they send it into USCIS. You want everything perfectly done. Then we'll have some blue folders that have various things in them, like sample questions, how to fill out an AR-11 if they move, how to get further advice if something comes up while their case is pending, and some other instructions that you will complete on the top part of the blue folder. Then the client goes to the copy station, they get everything ready, the envelopes prepared, and then they walk away with their completed application and a copy for themselves. And as I mentioned before, we really need you to stay till the very end, till the last person is done. It's really, really important to build rapport with your clients. They're from all over the world, and they may have different ways of viewing their legal problem. They may have different levels of English capability. They may or may not understand some of the complex words on the naturalization form. And recently I've been hearing reports from other attorneys that some of the immigration officers are asking them at the interview, do you know what this word means? Like, what is genocide? What is a Nazi? That sort of thing. So they're responsible for the content of their application. Therefore, you need to be able to find a way to relate to them and communicate with them so they understand what's going on. And some of the things that you might want to do is ask questions in different ways. And there's an example here about, arrests, being cited. What does that mean? Detained, charged, convicted. So try asking questions in different ways. We will have interpreters at every clinic, and some of the clients may bring their own interpreters. We do want word-for-word interpreting going on, not paraphrasing or giving opinions or suggesting things. And if you have any issues with interpreters, we want you to talk to the One America site coordinator. Also, the interpreters must sign the N400, and they must sign our yellow sheets. Okay, so now we're going to get into the nitty-gritty of citizenship. So naturalization is really just one way of becoming a U.S. citizen. One has to have been a permanent resident for a specific period of time. There are a couple of exceptions to that. Birth in the USA, of course, we've heard all about the birther movement, and people should revoke the 14th Amendment, but that's not the law. The law is if you're born here, you're an American. And then there's other ways to get citizenship through birth abroad to one or two U.S. citizen parents or deriving citizenship. So we have in your attorney notebook the various charts to determine if someone might be a U.S. citizen, and we have some questions on the intake sheet to prompt the recommended questions to get at this issue. And you'd be surprised, we usually have at least one and sometimes more folks at our workshops who turn out to already be U.S. citizens and they don't know it, in which case they can either file for an N600 certificate of citizenship or go directly to the U.S. Passport Office and file there. So that's part of your job, is to rule out whether someone is already a U.S. citizen. For those of you that are newer to naturalization, there are different ways that people get to this point. They may have had the typical route of coming in with a visa, then getting a green card, and now they're ready for citizenship, or they may have entered illegally without inspection, but somehow became eligible for a green card and then are now eligible for citizenship. Refugees and asylees can also become citizens after they've had their green card. And then some folks get their green cards outside the US. We call that an immigrant visa. And the typical ways that folks can get their green cards are either through sponsorship or through asylum or refugee status, benefits they obtain in immigration court, and then we have a whole range of obscure kind of country-specific programs, and then the humanitarian visas. The MAFNI program is a military program that's undergone a lot of problems the last couple of years, but essentially it was designed to allow certain non-immigrants to avoid having to get a green card by being invalid status when they enlist in the military. And that's an area that's had a lot of litigation the last year or two and all sorts of problems. So we often, if it's simple enough, we can handle it. Otherwise, we might refer them to the AILA Military Assistance Project. These are the main things that you need to be concerned about. Is the applicant already a citizen? Is the applicant eligible to naturalize? Could they be deportable? In other words, could a notice to appear issue? And if so, we want to refer them out for more concentrated legal services. And then what are the other issues do you see? What other information would be useful to know that they should probably get before they can resolve whether they're eligible? And or are the issues so complex that we just don't do them at the clinic? So if you have questions, I want you to know that there'll be a roving expert, which often is me, but could be some of our other qualified lawyers. And really, at all the workshops I've been to, all the lawyers and DOJ reps tend to collaborate with each other, and sometimes several people can put their heads together to resolve more complicated issues. And when in doubt, we'll refer them out. Oh, that sounds pretty good. When in doubt, refer them out. There's a few hot topics going on as of today, January 2019, that you should be aware of. One is the request for evidence, notice of intent to deny memo, where supposedly immigration can deny a case without asking for more information. And it's a little unclear what evidence is required to be submitted up front with N400s. We will come back to this in a little bit. The other is the notice to appear memo, which is really a scary memo, which gives USCIS more authority to issue the document that starts removal proceedings, the NTA. And there is a provision in this memo that talks about being able to do this prior to adjudication of a naturalization application, or if there's evidence in the file of fraud or certain criminal activity that would be a ground to deny for lack of good moral character. And so we're concerned about that problem. There's also a denaturalization task force now based out of LA, where they are going through old NATS applications and attempting to take them away. Usually these are fraud issues, but they can also be where the person obtained naturalization illegally. So we're concerned about this. And then right now, as I'm talking, there is a regulation to revise the N400 and instructions in the Federal Register, and comments are due toward the end of the month. And they would substantially increase the length and scope of the instructions, listing all the required documents, but it's very murky as to what's required to be submitted up front versus what can be brought to the interview. So this kind of ties into the RFE memo and what America is working on, comments to this rule. All right, basic eligibility requirements: must be 18, must have been a permanent resident for 3 or 5 years, and we'll come to that in more detail. Half of that time must have been spent physically present. So physical presence is not the same as residence. We'll talk about that in detail. The person must be a person of good moral character, which is defined both by statute and regulation. And the person speaks, reads, and writes English. They'll be tested on that at their interview, and has knowledge of US history and civics, also tested at their interview. And then they must be willing to take the oath of allegiance, which is on the N400 application itself that you can review. Sorry, my voice is a little scratchy here, so just a sec. So first, we have to determine, was the applicant lawfully admitted as a permanent resident? In other words, were they eligible for their green card when they got it? And so you'll see on the yellow intake sheet a lot of questions about this. How did they get their green card? In what category? And you may have to do a lot of probing. There have been some cases where people were not really eligible for their green card based on different things. An example is derivatives, in other words, dependent relatives of asylees or refugees who got their status before the principal. That's not allowed. Maybe someone lied on their green card application. That's something that we're really concerned about. You'll be asking a lot of questions about fraud and misrepresentation. For every visa application, the ESTA form, which is used for visa waiver applicants, and their green card applications. We want to make sure that everything that they disclosed on the forms and the documents they presented previously were true and authentic. Some of the tip-offs to this may be who helped the applicant. So if they were helped by a notario or they did it by themselves, there's lots of room there for mistakes. So we need to probe on that. And when you're not sure, this might be a tip-off to order a FOIA, Freedom of Information Act request of those visa and green card applications. It's better to know the real story up front than to be surprised at the interview with the officer saying, hey, you lied on your H-1B visa back in 1982, something like that. One of the grounds of removal is being inadmissible at the time of last admission. So we want to make sure, again, that they were lawfully admitted at the time they got their green card. So let's talk about residence. So this means continuous residence. And there's two rules. The general rule for most people is 5 years residence immediately preceding filing the application. There's a 3-year rule if the person is currently living in marital union with a citizen spouse, or the person received VAWA, spouse child of a citizen abuser. And in this context, residence means a principal dwelling place without regard to intent. So focus on that, without regard to intent. And you're going to also be seeing a trip history, which is part of page 7 of the N400. And so the trip history, which we'll talk about, will play a lot into residence. Where is the person primarily living? Where is their family? Where's their job? Or their work? Or the kids in school? Things like that. So back to the 3-year rule, you only need to show that you're married to a citizen spouse, you've been living together in marital union for 3 years, and the spouse has been a citizen for 3 years. So you'll want to probe, how did the spouse become a citizen, by birth or naturalization? If naturalization, you want to make sure they've had it for at least 3 years. There's another really great section, 319B, that deals with spouses of citizen employees who have jobs abroad, and they get their residence physical presence waived. They don't need any at all if they can meet the requirements. Secondly, there's a jurisdictional requirement. The person must live 90 days in the state or district where they're going to apply. And they can file 90 days early before meeting the 5 or 3-year residence rule. But they must maintain their residence until they take the oath. That doesn't mean they have to be here all the time, but their principal dwelling place without regard to intent must continue to be in the USA. We just talked about this, the 3-year rules. So the marital union plus the spouse having been a citizen for 3 years. And then they need half of that time, 1.5 years, physical presence. You may see a number of conditional residents. Those are the folks who immigrated based on a marriage and have a 2-year green card. There's also, periodically we see some investors who have their investor card for 2 years. The processing times for what they have to file for the 751 to get the permanent card is so long now that they may have already accumulated 3 years residence. So you'll want to verify that they have the full 3 years before they can file under this category. Now we'll talk about physical presence. So before we said the 5-year rule, so they need half of that spent in the US. And this doesn't have to be continuous, uninterrupted, it's in the aggregate. Under the 3-year rule, it's 1.5 years. And then under the employment abroad, qualifying employment abroad, they don't need any physical presence, except in this situation where a permanent resident can preserve their residence. They can do this by filing an N-470 if they have lived continuously in the US for at least a year before they file, and then go on to pursue their qualifying job abroad. The qualifying jobs for them, as well as for the citizen spouses, are typically either an international organization for which there's an actual list in the USCIS policy manual, or certain US companies engaged in international trade, certain religious people, and some military folks. Another thing that you may run across is that someone was abroad for a period of time and they had a re-entry permit. A reentry permit is like telling USCIS, hey, I've got this job or opportunity or school that I am planning to go to, but I am planning to keep my primary place of abode in the USA. I'm just not going to be here for a year or more. So you file for the reentry permit while you're in the US. They're usually good for 2 years with an optional extension. But the 2 years that you spend abroad do not count toward what you need for the 2.5 or 1.5 years physical presence above. So it's basically, you're putting USCIS on notice that you're trying to keep your residence here, but you've got this opportunity to do something specific, and you'll be back, knowing that that time abroad is not going to count for your naturalization eligibility under the physical presence rule. So there are a set of presumptions in the law in terms of trips abroad. And again, the form, the N-400 on page 7, asks you to list all your trips since getting your green card, or actually it says for 5 years. The date you left, the date you came back, where you went, and was the trip under or over 6 months. So trips under 6 months are presumed to mean that you're keeping your residence here unless the border officer or immigration has some reason to believe otherwise. And again, we're going back to this definition of residence. What is your principal actual dwelling place in fact, without regard to intent? Trips over 6 months and under a year are presumed to have broken your residence unless you / the client rebut that presumption. So it's not automatic that you screwed up your residence. It's really fact specific. What did you do? And we'll talk about some more details about this shortly. Any trip over 1 year automatically breaks the continuous residence. So when the person comes back, they'll have to start counting all over again, waiting for 4 years and a day or 2 years and a day to apply. I mentioned earlier that there's this regulation that right now that would amend the forms, and that one would ask for 10 years travel history, or since getting the green card, whichever is shorter. So this topic about the trips, right now we're talking about as it relates to naturalization eligibility under the 3- and 5-year residence rule. So now let's talk about abandonment of residence, which is something else, but it's also the reason those questions are on the naturalization form. The government is probing to see if you might have abandoned residence, in which case you could be removable. So here the government has the burden of proof, and also you should know that only an immigration judge can take someone's residence away unless the green card holder voluntarily abandoned. There's a form called an N-407 that sometimes the Border Patrol tries to pressure people into signing at the border, or you can go and file it voluntarily at the border or at a U.S. consulate if you intentionally want to abandon residence. But otherwise, if there's a hullabaloo at the border when the person's coming back from a long trip abroad, the border officer cannot take your permanent residence away. Now, they may lift the card, but the person is still entitled to evidence of their permanent residence, and only a judge, through a final order, which of course could be appealed or litigated in the federal courts, but until there's a final order, the person keeps their permanent residence. Now, a long absence could also trigger a new admission, and we'll talk about the definition of admission shortly. And here, intent does come into play. If you recall, for Naturalization, your principal dwelling place, in fact, without regard to intent. In the case of abandonment, intent is a factor to consider, and usually it is the intent the person had at the time they left the US. Did they plan to come back, or were they planning to be gone indefinitely? So I've had clients over the years who had job offers abroad who were there under a contract for a very specific time. Usually that is not a problem, but again, it depends on all the facts and circumstances. And I've talked with somebody else recently who, for example, wanted to give their kids a cultural experience, and they decided to sell their house here, give up their jobs, and go live in Bali for an indefinite period of time. They weren't sure when they would come back. And I think that would work against them for abandonment. So the government will also look at the purpose and length of the trip. What did you do while you were gone? Did you run for office? Did you serve in the military? Did you give up your home here in the US? Did you bring your entire family with you or leave some of them behind? Did you quit your job or take a leave of absence? Were you able to have full access to your home while gone? In these two cases, matter of Kane and matter of Huang, are the leading cases on this subject. So these are very fact-specific questions. And again, looking at the white secondary screening form will help you kind of dig into some of the questions on the abandonment issue. So how are long absences impacting naturalization or abandonment? As we mentioned, abandonment is a ground of removal. A long trip can break your continuous residence for naturalization, or it could break your physical presence, or it could break your lack of jurisdiction, the 90-day rule prior to filing. And it can trigger a new admission, and there's a definition for that in the Immigration Act 101A13, which includes any of the items listed here. And we'll see how that plays into removal grounds in a little bit. So again, going through that trip history is really important, and especially digging deep into trips over 6 months and of course over a year. Now for the English language, history, and civics portion of naturalization, it's helpful to talk to the client in English first, and sometimes it's more of a confidence issue. They know more than they're letting on, and they still may want to use an interpreter. That's fine, but you kind of need to go over with them how confident they feel they will be in about a year, which is how long it takes to get a naturalization interview. Although shorter times if they're filing in Yakima or Spokane. So you might ask the client, are they in ESL, or have they taken ESL? Are they working with their family with flashcards and things like that? There's many, many resources available to help learn English. But some folks just aren't going to be able to do it. So there are a couple of exemptions here. The 50-20, 55-15, 65-20, what that refers to is the person is 50 years old and has been a green card holder for 20 years, or they're 55 years old and older and have had their green card for 15 years, or they're 65 and over and they've had their card for 20 years. And so if they meet any of those, you'll jot down on the yellow sheet that they're eligible for the exemption, and they still can bring an interpreter to their interview. We also, for folks that think they can handle the English, but they're not quite ready right now, we don't want them to procrastinate. In case they get a randomly selected case that has an early interview, we want them to start studying right away. And we'll have flashcards and all kinds of resources at the exit table as they're leaving the clinic. Lately at the interviews, the officer is asking applicants all the questions on the N400. So especially if you're quality review, or screener, we need the applicant to know and understand what each of those words mean throughout the application. At the interview, they will basically, if their English is pretty good, that will be tested just conversing with the officer. If it's not so good, you know, it'll kind of depend if they're exempt or not. They will write like the equivalent of like a 4th grade level sentence in handwriting, like my house is yellow, something simple like that. And then the officer will issue, they'll spit out 10 random questions from the civics and history, and they have to get 6 of them right. The folks that meet the English exemption still take the test. And we will have sample questions in their exit package, and they're also online. Also, when they go to their biometrics appointment, they're typically given the booklet with the 100 questions. And the applicants are allowed 2 chances from their initial date of interview to pass the test. I'm just going to talk briefly about disability waivers. We do not do them at our clinics because they're too complicated, but I want you to know about them anyway. So here a person can be exempt from the English, history, and civics requirement if they have a medical evaluation that shows that they are unable to learn due to a disability. And only certain types of medical professionals can complete the form. And there's a new policy memo out on disability waivers and what will be accepted. And at this point, immigration is now requiring the N648 at the same time as the N400 is being filed. Comments are open for that if you happen to have expertise in that area. So the disability waiver is different than accommodations. So if your client does not qualify for a disability waiver, but perhaps they're blind, deaf, or handicapped, or they're ill and in the hospital, for example, the immigration office will make accommodations for that. And the first few questions on the N400 specifically ask what the person needs for that. So for example, I had a case of few weeks ago where my client is profoundly hard of hearing. He can learn, but it's difficult because of hearing, and he was just able to get through the test. It was amazing. But when I arrived at the interview, I told the officer, she really needed to sit close to the client and speak very clearly and have her mouth, you know, pronunciate the words very slowly and clearly, and she did that. She was great. So use that opportunity if you see a client who could theoretically pass the test but needs a little help. The Oath of Allegiance is on the N400, and we also have it in the attorney notebook, so you want to show that to the client and make sure they agree to all of the subsections of the oath. But there are 2 areas that can be modified. One is based on religious belief on the oath or under God information there. And the other is where they have a disability issue. So that will also need some medical assistance, and we refer those cases out. All right, let's talk about the crux of naturalization, good moral character. There's both statutory section in the Immigration Act 101F and a regulatory section. So you need to look at them together. And the person needs good moral character for the period of the residence rule that they're using, either the 3 or 5 year rule. So they could have had some negative event in their life that occurred outside the good moral character period and still be able to naturalize. But by the same token, there's case law that says immigration cannot deny a case solely on acts outside the statutory period. They'd have to show that they had some further problems within the good moral character period. And we're not looking for perfect people. We're looking for case by case, average citizen standards of morality. Unfortunately, doubts are resolved in favor of the government. So if any of the attorneys or DOJ reps have doubts, we need you to talk to the roving site expert, a criminal law expert, or refer the person out. We're looking to see if the person is deportable, and if they are, would they have a defense in immigration court? Usually we have at least one experienced removal attorney at our clinics, so we rely on them to help a lot with this issue. And then we're looking for statutory bars during the 3 or 5 year period. And if they're not statutorily barred, would they be able to show good moral character in the positive exercise of discretion, weighing the good facts and the bad facts? And they may have a temporary bar. In other words, if they just wait the 3 or 5 years, maybe they'll be eligible to file later. So these are the main issues. Are they deportable? Are they inadmissible? Is there good moral character bar, permanent, temporary, or discretionary? Are they aggravated felon, which has a specific statutory meaning? And assuming they were in removal proceeding, could they get any relief in front of the judge? So these are the statutory bars. I'm not going to go into them in too much detail, but I'd say that the most common ones are crimes involving moral turpitude, 2 or more offenses, drug offenses, smuggling, and false testimony. So and with regard to the habitual drunkard, there's not a real definition of that, but CIS tends to kind of focus on multiple DUIs and what the client has done to overcome that. And then you want to definitely see court records that show how much time the person spent in jail, if any. The statutory permanent bars, meaning the person can never get naturalization, are ag felons and certain Nazis, terrorists, etc. And then there's kind of a catch-all that kind of depends on the facts and whether the person can fall into any of the exceptions or waivers around that. The regulatory bars also have some permanent bars. Murder convictions, certain ag felons. There is a Supreme Court case to look at, Sessions versus DeMaya, about what is exactly a crime of violence. And then there's some other bars: willful failure, refusal to support dependents, and extramarital affairs tending to destroy an existing marriage could be a bar, and we have some questions on the yellow sheet that get into that. And then we have some other criminal acts, those with convictions and without convictions. So let's talk about false testimony versus misrepresentation. So for good moral character, false testimony requires intent to get an immigration benefit under oath, and it can be oral before an immigration officer. But it need not be material, which is what's in the misrepresentation statute. So there's some possible defenses here. I didn't remember, I didn't understand, it was an innocent mistake, etc., etc. Misrepresentation is both a ground of inadmissibility and a ground of removal. And these apply to documents and testimony for any benefit under the Immigration Act. And misrepresentation must be willful and material. These other cases here, you might want to take a look at them. One is a denaturalization case and one is a misrepresentation case. False claims to citizenship on or after September 30th, 1996 are important. Prior to that date, false claims to citizenship were considered just misrepresentation, for which there are waivers available, but since then there aren't. And the false claims go to any state or federal law, not just an immigration benefit. So we have some questions about, applications for licenses or permits or scholarships or government loans. Those types of things might apply. There's a new case that just came down at the end of December called Matter of A.J. Valdez. It's a Board of Immigration Appeals case, and although that doesn't necessarily govern naturalization, a person could end up in removal proceedings, in which case it would then apply. And here the court said that the applicant's signature on a form presumes that they know the contents of the application and the truthfulness. The court will look at the facts and circumstances to see, what occurred and why the person said what they did on the form. In this case, the Valdezes did not ask for an interpreter, did not ask for an explanation. They were religious workers who did not do the work they said they were going to do. And they were helped by someone to prepare the application. And the court found that their testimony was not credible. And so this case is disturbing in that it puts a higher burden on our clients to really know and understand what's being done for them. And it puts a burden on attorneys and DOJ reps to make sure that our clients know what's being done and that all their questions are truthful and knowledgeable. This kind of ties into what I mentioned earlier about some of the USCIS officers asking the clients if they understand the questions as well as the answers. Because, on the N400, I think it's pages 10 to 15 or 16, something like that. There's an endless supply of security questions, and they're all yes/no questions. And if your client just sits there and nods their head, yes, no, we want to make sure that they really understand the question and the answer is truthful. If someone might be subject to a discretionary bar, these are some of the things you're going to want to look for. You're going to look at the negative versus positive factors. If they had a criminal issue, have they rehabilitated, or if they had a drug or alcohol problem. The catch-all is a phrase back in the statute that talks about we can consider other bad conduct outside the good moral character period. It doesn't mean they will, but there's an argument to be made there why it shouldn't apply. We have a bunch of materials in your notebooks about who must register for the Selective Service, and if they didn't, what do they have to do? We have addendums for the N400s and instructions on how to get these status letters from the Selective Service. So this kind of distinguishes the negative and positive factors you might want to take a look at. Again, don't forget, I'm sending you the PowerPoint by email. Other things to look at. Again, this goes back to traveling. Did they travel abroad before or after their conviction or offense? And were they gone for more than 6 months? Because if they were, it might trigger an admission. So some of the grounds of removal, for example, crimes involving moral turpitude must have occurred within 5 years of admission. some of the other ones could have occurred anytime after admission, and that makes a big difference as to whether a person will be removable or not. So again, this all ties into the travel history. And then we want to make sure that the person obtained their green card properly and that everything was properly disclosed on their prior immigration forms. This slide's kind of a comparison of removal and inadmissibility grounds. Both of them have about, I don't know, 30, 35 grounds. Removal means the person's in the US or has been admitted and the government wants to kick them out. Inadmissibility has to do with being eligible for a visa or a green card because those are applications for admission. And the main categories that are common to both are crimes, health, terrorism, public charge, medical issues. So some of the grounds are similar and some of them are different. So I've tried to list here how they might be a little bit different. And the same here. So let's talk about criminal issues in the context of our workshops. So most significant criminal issues, we're going to refer the cases out. Fundamentally, we must be able to see the court records. And this is because what happens in criminal court does not have the same view or impact in immigration law. So what we might think of is a conviction in criminal court or is not a conviction in criminal court could still be a conviction in immigration court. So we always go by the records because the way the case law and the statutes work for immigration law, we need to know what was the charge, what was the final conviction, did the person plead guilty or admit guilt at any point along the way, and was there any kind of a sentence or post-conviction relief? And if we don't know the answer to those questions, then we can't make an analysis. So records are essential. And when America does their outreach, we do request people bring records, but they don't always. And then if they do, we try to always have a criminal or immigration attorney on site or available by phone for questions before we refer them out. If for simple things, we might be able to keep working on the case that day. The N-400 does ask for citations to any offense anywhere, and so we do have to list traffic tickets and foreign offenses. We also have an account set up for Washington Court's J-Link, and many of you can run watch reports on the computer. We may have to tell the client to get an FBI background check and or go to the court to get some records. So please make notes on your yellow sheet whether they have them or not, and if you're referring them out, tell them what they need on the red slip. Okay, so was there a conviction? And this is the immigration definition of conviction: formal adjudication of guilt entered by a court, or if it was withheld, the person entered a plea of guilty or nolo contender, or has admitted sufficient facts to warrant a finding of guilt. And there was some form of punishment or penalty or restraint on their liberty. And so in Washington specifically, we have these various procedural options, but we need to know what the person admitted to, if anything. In some cases, there's an oral recording, and we would need either the recording or the transcript, or it's noted on some of the documents in the court file. These are the documents that consist of the record of conviction. So interestingly, An arrest report is not part of the record of conviction, but the immigration officers do ask for it. And it's even in the instructions and in that proposed changes to the form and instructions. So many attorneys argue either that the government's not entitled to the arrest report or they submit it under objection. And I believe in this case, USCIS is looking for what was the charge and how has the client overcome or rehabilitated from that. But this is something that you might want to discuss with the attorneys who are at the clinic that day about whether or not to submit an arrest report. But I know we usually recommend never ever submit them with the initial application for sure. Washington Defenders Association is a great resource for immigration consequences of crimes. We have some of their materials on our Dropbox account that you'll have access to, or you can go directly to their website. So some of the grounds of inadmissibility and removal provide that a conviction is not required. All you need is an admission to the commission of a crime. And there is a question on the form: have you ever committed a crime for which you have not been arrested? And so for an admission to be sufficient for removal purposes, the applicant must be presented with all the elements of the crime and must admit to all of them, and they must be voluntary. So there's a lot of, how shall we say, opinions about how this plays out in reality. We also want you to be aware of whether the client had an attorney when they had their criminal case, because there is both Supreme Court law and Washington Supreme Court law on ineffective assistance of counsel, where a criminal defendant pleads guilty to a crime that has an immigration consequence, but they were not advised of the immigration consequence. And so in those types of cases, we refer them out to lawyers who do post-conviction relief to see if they can get the case vacated. So I mentioned a couple of trends this past year that we need to keep in mind as we work on these cases. The notice to appear memo, the link is there. They are phasing that in. So far they've phased it in with regard to adjustment cases, extensions, changes of status, and then the humanitarian visas, UT and VAWA. But there is language in the memo that deals specifically with N-400s that means an NTA could be issued and trigger removal proceedings if it's going to be denied on good moral character grounds based on a criminal offense. So not any criminal offense, but the person has to be removable for that criminal offense. And the same for fraud or misrepresentation or, quote, abuse of public benefits. There's also another section in that memo that deals with issuing NTAs while the N-400 is pending. So this means they could do it even before the client has an interview or before the case is denied. So this is why we're really concerned nowadays about making sure we're doing really careful screenings, because we don't want anybody ending up with an NTA while their N-400 is pending. The second trend is the RFE NOID memo. RFE refers to request for evidence. NOID refers to notice of intent to deny, where immigration can deny a case without requesting either of these. So RFEs and NOIDs have been sort of a pain in the butt the last couple of years under this administration, because they keep asking you to justify things, et cetera, but they can also be a blessing because it gives you a chance to explain yourself. now they can go ahead and deny a case without asking for anything. So the real question is, what is absolutely required to be filed upfront with the application so as to avoid an RFE-NOID memo problem? So this list here is currently what's online under the N400 instructions. And after this memo came out, immigration put these checklists of required initial evidence up for most forms. But the memo does say you can't rely on that list. You have to rely on the regs and statute. So, for example, typically we just copy the permanent residence card. But if you're going to rely on the 3-year marriage rule, you'll need the marriage certificate. They don't mention here evidence of the spouse's citizenship or the 3 years living together. So to me, that's rather murky. And I personally try to get my clients to have all that stuff up front. And that's something we can discuss at the clinic. Attorneys may have different opinions about that. But we do have a little section now added to the blue folder that the client takes with their prepared N400 that says to add these things to their application if it comes up. If you're filing under one of the military grounds, you need this N426 and their DD-214s from the military. And if you're filing under 319B, you need to show the spouse's employment abroad. But note again, there's no item on this list to show your spouse is a citizen. So, I mean, to me, I think you should include that. So this ties into the proposed changes to the N400. So again, this is the regulation that's out for comment right now. We don't know what the final product will look like. So currently the rule is you show trip history for the last 5 years. One issue I have, and I have a case where the person's filing under the 3-year rule, so why do you have to show a trip history for 5 years? Because outside of 3 years, they were not a green card holder. The prior slide has the current list of, quote, required documents. The new N400 instructions would have much more detail about required documents for every kind of N400 filing. But in the same paragraph, it says you must file these documents with your application. But then it says in the same paragraph, you can bring them to the interview. So that really needs to be clarified. And then they've added some other fishing expedition security questions that are kind of squirrely. So right now, those are not on the current form. I mentioned earlier that there's a denaturalization task force, and these are the grounds that they can take your naturalization away. You got it illegally, there was fraud and misrepresentation, you became a member of the communist or other totalitarian organization within 5 years of naturalizing, or you were discharged in less than honorable military discharge. But what's important, really important to know is that denaturalization can be both a criminal proceeding and a civil proceeding, both of which can have your client end up in removal proceedings. So now we're going to go over the red flag issues. Immigration removal issues. So one thing you should do in every case is call the EOIR number. That's the immigration court. It'll ask for the A number, and it will either say there is no match, or it'll say give you more information, like person was ordered removed, or the case was administratively closed, or the next hearing date is such and such. So please, if you call the number, write down the results on the yellow sheet. Don't forget to do that. We really want to know if clients had prior deportations. Many of them really don't know what happens to them, and there are a number of legal consequences and orders that a client could have at the border if they were caught either right at the border or shortly within the interior. So they could have received voluntary departure, voluntary return, expedited removal, allowed to withdraw their application for admission, or in the old days we called it exclusion. So where the client typically doesn't know what happened, we often will need a FOIA. But we also need to know whether those problems and any subsequent re-entries, when they occurred, how long they were, how long the person was here, based on dates of which Immigration Act provision was in effect, and whether they were disclosed on their green card application or any prior visa applications. So you'll see a whole bunch of questions about this on the yellow intake sheet. Please take careful notes, and again, when in doubt, red slip them for FOIAs. Again, we want you to probe whether they gave contradictory or false information or false documents or made material omissions in visa applications, asylum, refugee applications, amnesty applications, green card applications, whether they ever testified falsely under oath at the consulate, the border, before ICE, or the court. Do they have any trips over 6 months? Sometimes the tip-off to that is the client says, I moved back to my country and I would come to visit the US every year. That means kind of psychologically they've kind of inverted what they were supposed to be doing. So you need to probe, what were they actually doing and how did they preserve their ties here? One of the areas that's become more difficult lately is, and there are several security questions about this, if the person helped or provided material support to a group attacking others. Sometimes this comes up in refugee or asylee cases. Trig and CARP have to do with extra security analysis that the government does on cases, and they tie the application up for months, years, ages. Some of them are Muslim based, and that can get really sticky. We have a couple of chapter members who specialize in that area that you might want to refer out. Another red flag is if an asylee or refugee took trips back to their home country, which could look poorly on their original claim. It depends on changes in country conditions, how long they went back, what they did there, and when. Did they go back while they were an asylee refugee or while they had their green card? And there's some case law on this, and there'll be very fact-specific questions, so either talk to the roving expert or some of the other lawyers there, or we might want to refer these cases out. There are cases where folks immigrated through USCIS, but there was a pending EOIR case, immigration court case, where there could be a jurisdictional issue. In this case, it's useful to talk to our on-site removal lawyer if you come across an issue like that. Failure to file taxes. So here we're looking at folks who may be on tax payment plans. We don't want them to file until they're on the plan, and there is a record from IRS that they have the plan. We're also looking at some other income tax issues and whether they properly claim dependents. If folks didn't earn enough money to be required to file a return, then we need to know what the minimum earnings were required for that year, and is that what they made? Failure to pay child support or alimony goes toward good moral character, and we want to know, was it intentional or what their reasons were, stuff like that. And then through executive order, the Trump administration's really into perceived, rightfully or wrongfully, public benefits abuse. So here we're looking to see, was the application for public benefits truthful? Are people in the family not covered by the benefits using the benefits? Is the person living abroad? We want to look at their trip history. Some programs like SSI require you to report if you're going to be gone for 30 days or more. Otherwise, they don't want to be paying you benefits if you're not living here. And then another factor is letting people use your food stamp card that are not entitled to it. Smuggling's a big issue. False claims to citizenship, registering to vote. This can be a problem, especially if there are motor voter rules where sometimes the Department of Licensing makes a mistake, not realizing the person's not a citizen, and the person registers inadvertently. There's some ways to get around that. And then we have a couple of these other issues here. All the criminal stuff. If a person's currently on probation, theoretically they can file, but the case will not be approved. So there's a decision to make about whether it's worthwhile to file now or wait till the person is done with probation or parole. And then we want to know, were there criminal problems before or after they got their green card? Was there travel that would prompt a new admission? All right, so we're kind of getting a little bit behind the times here. The next several slides are the N400 itself. These come from the Immigrant Legal Resource Center, and I think you can go through them when you get your PowerPoint, but let's see what else we want to focus on. Names. Names are a big issue. We want to make sure, especially here, that we have all the names that the person has ever used. Note, it says nicknames, aliases, maiden names. This is partly for them to run the security check. If the client wants to change their name, they can do it before or after naturalization, but if it's before naturalization, they need a court order for that. There is a procedure where they can get a judicial naturalization that does change their name, but I'm not really sure how they're doing that these days, so I generally tell the client to go to their local court and do a name change through the court. You don't need to do them for divorces and divorce and marriage names. For Social Security number, we only want them putting in here their real Social Security numbers, not ITIN numbers and not fake Social Securities. The date the person became a permanent resident should be on their card. Here are the English exemptions kind of spelled out for you. And then the accommodations for people with disabilities or impairment, you can specify what you need here. Addresses are really important. Make sure that you cover the entire 5 years. These questions go towards looking at whether or not the person might already be a U.S. citizen. They're asking for physical information. So here they're asking for 5 years worth of employment. So be sure to include time spent as a homemaker or unemployed or as a student. Make sure the entire 5 years are covered. I usually start with the most recent first, working backwards. And there's lots of pages for addendums. This is the all-important trip history that we've been talking about, especially where the trip's more than 6 years. And so the client will be giving you that information, hopefully off their blue intake sheet. So please, please look at the blue sheet. And again, if you're quality review, you'll be reviewing this form and you'll want to go over the facts and circumstances about trips more than 6 months. Also, they ask for the date you left and the date you returned, but the policy manual says we do not count, so for the total days out, we do not count the days of arriving and departing. Only trips that are over 24 hours. So if you left on January 1st and you came back on January 8th, you're going to count the days, the 2nd through the 7th, as your total here. All these marriage questions are really important because they're going to, especially if someone immigrated based on marriage or as the unmarried child or married child, that, you know, we want to make sure that the person was legally able to get their green card in the first place. So they ask about the spouses, prior spouses as well. And if you see that the marriages were really short or they line up really close to each other, now we're starting to look at marriage fraud and or bigamy, where is it possible the person was married to 2 people at the same time? They want to know about all the kids, whether or not undocumented or not, biological stepchildren, born out of wedlock, etc. And then now we get into all the good moral character questions here for the next several pages. One of the hardest questions to get information from clients is this one about being a member of organizations, associations, funds, foundations, parties. You kind of have to explain to them what that means. And there's no time or age limit, so pretty much any time. So things like the Girl Scouts, the Boy Scouts, the Pioneers, trade groups, professional groups. I don't usually put churches because they don't have a membership unless it is a membership-driven religion. These also tie into some of the claims refugees, asylees might have made, especially if they claimed they were being persecuted by a particular group. So we were kind of looking, cross-referencing information about groups and those asylum refugee applications. Let's see. Notice that a lot of these questions, have you ever? Okay, and this is the one about the crimes. So have you been convicted of a crime or offense? Have you placed in alternative sentencing, et cetera, received a suspended sentence, been on parole, been in a jail or prison? Actually, it's covered up here, but it says, have you been cited for any offense? And that's where you have to say yes and include the details. So include traffic violations here. I don't include parking, but I do include, you know, failed to stop at a stop line, speeding, illegal right turn, that sort of thing. Don't forget to ask about political arrests and any arrests outside the United States. This should all be coming from actual court records or the client's memory on traffic violations. This one is the key. Have you ever made a misrepresentation to obtain any public benefit in the US? Have you married someone in order to obtain an immigration benefit? Then the proposed change would say, have you married or attempted to marry someone? Have you sold or smuggled drugs, been married to the... And 31, the really critical one, have you ever given any U.S. government officials any information or documentation that was fraudulent or misleading? Have you lied to any government officials? So that includes the forms. It includes consular officers, border officers, ICE officers, USCIS, or the immigration court. And then the next several go to the immigration history. What exactly happened? And here again, a lot of times the clients don't know, and we might need to do a FOIA. And then the next several questions have to do with the military and selective service. And then these are the questions about the oath of allegiance. So you want to go over those with the client. Do they agree to all of them, or do they want to take a modified oath, the bearing arms and the under God oath portion? The interpreters will sign here. Okay, so let's talk a little bit about fee waivers and the reduced fee. So the general filing fee is $725. That's $640 plus $85 for biometrics. Applicants 75 and older don't pay the biometrics, so they can get a full fee waiver of the $725 and pay $0 on Form 912. So it's based on receipt of means-tested benefits or income less than 150% of the poverty guidelines or economic hardship. We don't do the economic hardship grounds at our clinics. Back in October this year, immigration came out with a proposed rule to eliminate the fee waiver based on public benefits. And we might see something on that as a final rule in the next few months. We hope that won't be the case, but generally most of the clients we see have the means-tested benefits document with them, or we look at their tax returns to determine the federal poverty guidelines. We have the guidelines in your notebooks, and we have samples on how the I-912 looks. The screeners don't need to get into this, but the quality review person will be reviewing the completed forms. There's also a reduced fee option that it amounts to $405. That's based on someone having more than 150% but less than 200% of the poverty guidelines. So as you remember at the very beginning, we talked about making sure that your client isn't already a citizen. So these are just a couple slides on the general rules for automatic acquisition of citizenship where a child is born abroad to one or both citizen parents. And we have the charts in the notebook that you can go through. They're all very date specific, when the person was born, and then how much time you have to show the parent was in the US. And some of those statutes vary based on a requirement of physical presence or residence of the citizen parent. There's also a separate chart for kids born in and out of wedlock. There's a recent case, Sessions versus Morales Santana, that deals with the folks born out of wedlock and how mothers and fathers will be treated the same for kids born after June 12, 2017. Probably won't see those cases for a while. So there's some probing questions here to look at and some resources. There are different definitions of child in the immigration sections of the Immigration Act versus the citizenship section. So you want to take a look at those. Some of the problems that we see have to do with delayed birth certificates. These are particularly problematic with the passport office and CIS, especially if the birth certificates were registered years after the child was born. A Other problem cases are where the kid was born by a midwife. There's been some litigation along the southern border by the ACLU. We would kind of need to know if the midwife was on the fraud list. And anyway, these cases are going to be complex. You'll want to refer out. Another really difficult area right now is artificial reproductive technology, including there's a rule now that says that the citizen mom can be either the biological mom, in other words, the egg donor, or the gestational mom. She's carrying the baby, but not the egg donor. But there's no similar options for the men. And there's also a whole area of problem cases dealing with surrogates. You may or may not come across this, but it has to do with whether the child born abroad was, the parent filed a record of birth abroad with the U.S. consulate. Then we have derivative citizenship, and here's where a permanent resident child can derive citizenship after birth to one or both U.S. citizen parents, and there's a grandparent exception in there, so you need to ask about status up the chain, and also determine if any of them served in the U.S. military, because there's a way to transmit citizenship that way through the generations. There's more charts on this in the notebook. And then we have the Child Citizenship Act here. There's some questions on the intake sheet as well, the blue sheet and the yellow sheet. If the applicant for naturalization has any kids under 18 that are permanent residents, they will automatically become U.S. citizens if the parent naturalizes while the kid is under 18. So the kid doesn't need to do anything. They can just right away file for a passport. So kind of going back to the red slip idea, we just want to highlight that we're really looking to see if the person could end up in removal proceedings, or if we just don't have enough information today to make a decision about this person's eligibility, in which case you can tell them to go get the information and come to the next clinic. Or if the case is so complex, they really need to get private counsel, which can be a private attorney or a nonprofit organization that can spend more time with them. Questionable immigration history, can't verify the details, there might be false statements or omissions, prior removal issues, criminal issues, abandonment or break in continuous residence. They might need a disability waiver, or they don't qualify for English right now and they don't speak enough English. So they need to get into a ESL class. We don't really want you to red slip clients who maybe they're just a month away from being eligible. We can still prepare everything, and then on the information that they take with them, boldly make some notes, the earliest date that they can file. Again, depending on the timing of the clinic you're at and the status of the proposed changes to the forms, we might want to consider when that new form goes into effect in relation to the timing, so that if they're not going to file right away and we know the form's changing, we might want them to come back to the next clinic. If they seem eligible but they don't have their check or money order today, or they just are missing small pieces of information that they can get at home, use your judgment or talk to the roving expert, and we can discuss whether they should proceed or get red slip today. Final reminders. I can't say this enough, and I'm sorry to keep beating it over the head, but these yellow forms, we really need you to use the checklist and remember to sign your section of it for your station, because the notes that you provide are going to be reviewed by other stations, and we absolutely need them in case we have to track down the client or talk with them after the event. And that does happen from time to time. Screeners, QR, we really want you to focus in depth how they got their green card, any past encounters with the different agencies. Is there something that would make your decision about eligibility better if they had more information? Reminder, screeners and QR should not be seeing the same clients. We want two sets of eyes. In the back of your mind, we want you thinking about the NTA memo and the RFE memo. And then refer out criminal stuff if it's too complicated or it's going to take more than 20 minutes, or our criminal site expert thinks it's too difficult for our clinic. So if you have any further questions, here's my email. I just wanted to mention that I'm recording this today not before a live audience. So I welcome you to send me questions and or critiques, or if something was amiss in this presentation, please give me the feedback. And also, we really want your feedback on the intake sheets once you start using them, and the newer materials that we've prepared in your notebooks. Okay, and I just wanted to thank you again for your patience and your volunteering, and it means a lot to us, and I think you'll find it to be a really worthwhile experience, and the clients are ever so grateful. And then one final plug, we are actually going to be going to Lobby Day in Olympia. See, I'm from California, I want to say Sacramento. Let me just get the date, February 6th. And if you'd like to come and help us explain to our legislators why they should continue to help fund this program, we would love to have you. Just let me know. We look forward to seeing you at our next clinic and or at Lobby Day. Thank you very much.